Hi, I'm Brian Foley, and I'm here to talk to you about 8.05 of the Texas Penal Code. It is the defense of duress. And it says in subsection A, it is an affirmative defense to prosecution that the actor engaged in the prescribed conduct because he was compelled to do so by threat of imminent death or serious bodily injury to himself or another. And that is the basic of structure of the defense of duress. It's focused on the threat of this other person that is not the actor. Okay, and when we say actor in this instance, we're not talking about like Tom Cruise and other actors. I could probably have picked a younger actor nowadays, but you don't get out much as a lawyer now. So an affirmative defense here means that you, as the defense attorney, are going to have the burden of production and persuasion. So let's look at, if you want to cross reference with me here, it's going to be section 2.04 of the Texas Penal Code called affirmative defenses. And it says in an affirmative defense that the issue of the existence of that defense is not submitted to the jury to let you, use that defense unless evidence is admitted supporting the defense. Could be by the prosecution, could be by defense, right? But the prosecution doesn't have to put any of that evidence in if they don't want to. If the issue of the existence of an affirmative defense is submitted to a jury, then the court shall charge the jury that the defendant must prove the affirmative defense by preponderance of the evidence, meaning 50% plus one. So that means that if you want to prove somebody threatened you and that's why you robbed the bank, then you've got to prove that by a preponderance of the evidence. You want to have a jury instruction that goes to the jury and tells them that they can find you not guilty because of that. And there'll be this application paragraph that says, did they think that this all happened in accordance with the duress statute here? So let's look at subsections B, C, D, and E. Subsection B, in a prosecution for an offense that does not constitute a felony, so misdemeanors, it is an affirmative defense to prosecution that the actor engaged in the prescribed conduct because he was compelled to do so by force or threat of force. So that means not just threat of imminent death or serious bodily injury, but force or a threat of force. I'll punch you in the face, not I'll cut your arm off, right? I'll beat you to death is serious bodily injury. I'll kill your child is serious bodily injury or death to yourself or another, right? That's enough for a felony. For a misdemeanor, it's I'm going to punch you in the face if you don't steal that bubble gum from the gas station. So that's the difference between subsection A and B. Subsection C, compulsion within the meaning of this section exists only if the force or threat of force would render a person of reasonable firmness incapable of resisting the pressure. So I'm going to kill your kids if you don't rob the bank. That is something that a person of reasonable firmness probably would go ahead and do. I'll rob that bank so that my kids don't get killed. That's a reasonable firmness kind of irresistible thing. But if it's, I'm going to tickle you with this feather if you don't rob the bank, well, then a person of reasonable firmness would say, screw off. I'm not robbing the bank because you have a feather. All right, the next subsection, D, the defense provided by this section is unavailable if the actor intentionally, knowingly, or recklessly placed himself in a situation in which it was probable that he'd be subjected to compulsion. So if you agreed to go be the getaway driver at a robbery, first off, under the law of parties, you're going to be guilty of the whole robbery. But then if you had agreed to do that, and then he says, okay, well, we're going to rob a second bank that you didn't agree to. Okay. And you say, nah, I'm only going to rob this first bank. We're going to get caught on that second bank or whatever. And he says, well, I'm going to shoot you if you don't drive me to the second bank. You can't say duress on the second bank. Okay. You have put yourself there in a situation in which it was probable you're going to be subjected to compulsion. Subsection E, it is no defense that a person acted at the command or persuasion of his spouse unless he acted under compulsion that would establish a defense under this section. So that means that you can't say, I'm not guilty because my husband told me to do it, or I'm not guilty because my wife told me to do it. I don't know when the last time that subsection was used, but I love that it's there, that people at some point said, no, I'm not guilty. My wife told me to do it. You might pull if you're a lawyer and you want to make a good joke with your buddies at the golf course, when you say, like, oh, I can't come because my wife told me to do it. You can tell your buddy, hey, it's duress is not a defense. Only lawyers would find that joke funny, but I find that joke funny, and that's what's important. It's it's a great day here at Houston Criminal Defense Attorneys. I hope you've enjoyed the offense of duress, section 8.05, and good luck out there. Don't forget to like and subscribe if you enjoyed the content. Share it with a friend, and if you need real help from a lawyer, give us a call or give a lawyer in whatever field or area you're needing help in. Give that person a call, have a consultation, and get some advice. Thanks so much, and we'll see you next time.